Dana Schwartz wrote in with a question for you, Ian. He wrote, we've heard that courts can't ask you for your passcodes to unlock your devices because of Fifth Amendment protections against self-incrimination. But recently, we've also heard reports about use of the All Writs Act to require defendants to unlock their devices themselves without disclosing the passcodes to the court. So is there a difference here? Aren't people still being asked to self-incriminate, or does this process effectively circumvent the Fifth Amendment? You still have to use something you know to unlock, but just not disclose it.
Well, I've been chatting to the EFF about this today, and I'm afraid to say that it does appear to be legal. They actually filed an amicus brief in the case which triggered all this, and they're arguing quite, from their perspective, that this is obviously an abuse of the All Writs Act. But it has been used by the US before, and I'm just trying to pronounce the name, but it's US Frixu versus Frixu. They have forced people to unlock their phones in this way. And there's an ongoing case in, I think it's Pittsburgh, where a bloke has been spent 7 months in prison because he's refusing to decrypt hard drives, which the authorities suspect may harbour child abuse images. Now, it's a bit of a sneaky workaround, but it is being used by law enforcement to try and get people to unlock their phones. We're still at the sort of the very early days of this, though. So there is a body of case law building up which would agree that this isn't a breach of the Fifth Amendment, but no one's taken it to the Supremes yet, and that could be very interesting if it does happen.